This is Michael Manrique from over at Affinity. Michael, good
Thank
morning.
you.
How are you?
Good morning, Jeff. Thank you so much. Hello, everyone. Want to welcome everyone. Thanks for spending a part of your day with us. I'm Michael Manrique again, as Jeff mentioned. I'm with Affinity Management Services, and we're a few minutes away from getting started on today's webinar, which is called Why Updating the Governing Documents of Your Association is Critically Important. We'll get started in just a moment, and while we wait, let's make sure to remove all distractions around you. So go ahead and close the doors, turn on Do Not Disturb on your phone, or try to remove as many potential distractions as possible so we have your undivided attention and you get the most out of our time together. Now, I know your time is valuable, especially as a volunteer board member or a licensed community association manager. So I want to be very respectful of that today. Before we dive in, I want to do a quick warm up so I know who I'm speaking with today. So in the chat, Jeff, the chat's available.
Yep.
All right. Please drop two things if you can, if you could hear me. How long have you been a board member or community association manager, and either the community or city you're attending from? So go ahead and do that now in the chat.
You have to tell us who's the farthest away.
All right. We see Tallahassee, 2 years, 4 years, Cam. All right. Over 20 years.
Tallahassee, it's all your fault that some of these laws don't make sense. Come on.
Awesome. All right. So I'm seeing folks from all over the place, 10 years, 20 years,
Wow.
3 years. Awesome. So we got a nice mix of experience levels, whether you've been on the board for 6 months or 20 plus years, as I've seen here. What we're covering today applies to all of you. For those of you who don't know me, my name is Michael Manrique, and I serve as the Director of Business Development for Affinity Management Services. For the past 19 years, our company has worked alongside condominium and HOA boards across Florida, representing more than 30,000 units from large-scale master associations to luxury high-rise condominiums. Over that time, I've personally had hundreds of conversations with volunteer board members, and one theme, I should say, keeps surfacing, especially right now, as the cost of everything continues to climb and budgets get tighter. Most boards don't realize that the very documents they govern under may be limiting what they're able to do about it. Speaking of rising costs, let's pull on that thread for just a moment. I want to launch a quick poll here while everyone's engaged. The question is, how confident are you that your current management company is equipped to have an effective conversation with you or your board about combating inflation in the upcoming budget season? Your options are very confident, somewhat confident, not very confident, or not at all. All right, so just take a few moments and fill that out. Jeff, you wanted to add something?
Just saying they're coming on in. Michael, can you see them or not yet?
I see the chats and I see the poll.
Okay. And are you able to see the percentages at this point?
No, I am
okay,
not.
Cool. Okay, when they slow down, I'll share all that.
I saw someone's comment was totally incompetent, so that makes me feel good.
And folks,
the options.
That makes me nervous for you. Okay.
Yeah, some folks are entering their answers in the chat. We actually enabled a poll on the screen, so if your browser is up to date, you should be able to see an actual interactive poll in which you make a selection of the options via multiple choice. And it looks like they've slowed down and they're coming in a little bit slowly now. Want to give it another 20 seconds or so.
All right, great.
And then while we're doing that, when we're done with the poll, Michael, I'm going to go over a few housekeeping items on how people get certificates and credits and all that good stuff. And then we'll get on with the rest of the material. All right, so let's end the poll now. It looks like the numbers have slowed down. And we're going to share the results on the screen.
All right. Yep, I got it. So It looks like 43% are somewhat confident, 36% are very confident, 15% are not very confident, and 6% not at all confident. And you know what? That tracks with what we're seeing across the industry. Here's the thing. Inflation isn't just a financial conversation. It's a governance conversation. And how effectively your association can respond to it is shaped, sometimes silently, by what's written in your governing documents, which brings us to today's topic. So before we get into the content with Emily, right, I'm going to hand it over to Jeff, as he just mentioned. He's our moderator today to walk through what's required for your CEU credits. Jeff, go
Thank
ahead.
you, sir. And a pleasure to be with you. Thanks for collaborating and inviting us to participate. We appreciate that. So, folks, a couple of things. Michael mentioned earlier the last thing we want to do is waste your time. So, the type of credit for today, while this is pertinent to everybody, regardless of your association type, the types of credits today are for licensed Florida Community Association managers. You'll get an OPP credit. And there's also a credit available, a CEU, for board members of an HOA if you're governed by 720. Again, there's some condo and co-op content, but in terms of CEUs, for board members of a homeowners association and licensed community association managers. Now, the way you will interact and ask questions relating to the course material, you're already aware of the chat, and I want you to keep the chat area open. You will use that, and I'll get to that in a moment. But for course-related questions, you're going to use what we call the Q&A module, different module. So you'll use that to ask course questions. Try to hold off on your course questions until a little bit later, because what happens quite often is you jump the gun and it's something that will be covered a little bit later. So do the best you can to hold off until a little bit later with your questions. Again, the chat module will not be monitored for course-related questions. Now, the Q&A is not a requirement. We want you to hang out and stay with us at the end of the class, but that is not a requirement. The requirement is staying for the slides and the required evaluation, which I'm about to talk about next. In the chat module where you told us about where you are, your cities, and how long you've been doing this, later on we're going to place a link for the required evaluation to click on and fill out. That's the information we're going to use for two things: to help prove you were here if you ever get challenged. We help you out with that. And two, to collect the information so we can send you your certificates via email. They will be sent to your email address, to the addresses you enter on the evaluation page. That'll happen within 5 to 10 business days or so. Let's see here. For those of you listening today, maybe you're phoning in, listening audio only. You're obviously not going to see any of this. You'll visit kbrlegal.com, and on any page on the website at the top, there's a button to request a certificate up there. And lastly, even if what you hear today comes from Emily, our wonderful attorney today, none of this should be considered as legal advice. This is all educational in nature. If you have any questions, please contact your association counsel. Managers and board members should not be interpreting law. You can quote law, but you should not be interpreting the law. Michael, I am out of material right now. I am kicking it back over to you.
Awesome. Thank you, Jeff. All right. So today's session is called Why Updating the Governing Documents of Your Association is Critically Important. And joining us today is Emily Gannon, a firm member at K. Bender Rambam, one of Florida's most respected community association law firms. Emily has spent more than a decade representing condominium and HOA clients across Florida, drafting and amending governing documents, advising on covenant enforcement, fair housing, and the day-to-day legal questions that boards run into. She's also a frequent lecturer in our industry, so you're learning from one of the best today. Emily, thanks so much for being here.
Thank you, Michael. I swear, I think I do these just so I can get a little ego boost when you guys do my intro. I appreciate it. Yes, and I look forward to always presenting with you guys. Affinity is great to work with. We are, as Michael said, we're talking about amending your governing documents today. Lots of considerations, practical considerations for board members. Again, it does apply to HOAs and condos. I know only HOA board members are going to get the credits, but we are going to talk about condo stuff too. And again, it does all sort of tie back to the economy a little bit too. So I was happy to see that poll question today. And someone's comment was kind of funny. They said, I wonder if it was just the managers who responded and said they were very confident in their management team, which that is a consideration. We do know we have managers and board members listening to us today. So, but all right, so let's get to our slides. Hold on. Let's see if we can do this right, guys, because I am not that technologically savvy. Let's see. All right. I think we have it open. All right.
Looks good. You just got to start it and we're good.
Okay. All right. All right, so I can go ahead and click through. You guys can see.
You would just need to go to the top
Uh,
and start the slideshow.
where is it?
Next step, in between animations and record,
Oh, slideshow. There we go. My little thing
and
is,
then from beginning.
there we go. All right, there we go. All right, so there's our little intro page. Essentially, like we said, we're going to talk about updating your governing documents today. And here's some info on the firm too, if you guys don't know much about us. I did see some of the participation is all over the state, and essentially so are we at this point. I'm in our Pompano Beach office, but we have an office in Palm Beach Gardens, offices down in Miami by appointment, and an office up in Tampa, and an office in Orlando. So slowly but surely we're taking over Florida. But obviously wherever you are, we can help you out. Everything is via Zoom and emails at this point, so easy enough. All right, let's dive in. There's my bio if you want to know more about me. Okay, so start with, why are we here? We're talking about amending your governing documents. What does that mean? What governing documents? What do your governing documents even include? There's a hierarchy of what your governing documents include. There are different documents that we're talking about here. We say governing documents, and that's sort of the collective grouping of what we're talking about. The one at the top, the one that kind of controls over everything typically, is your declaration. In the world of condominiums, that's your declaration of condominium. In the world of HOAs, it's typically called something else: a declaration of covenants and restrictions, declaration of easements and covenants, some variation of those words essentially. But either way, declaration. That's what, is at the top of the hierarchy. We joke that the easy way to remember this is a little dab will do you. So the hierarchy is your declaration, your articles, then your bylaws, then any rules or guidelines you might have, architectural guidelines. Those are sort of the bottom of the list there. Your articles of incorporation, that's a different document too. That's what sort of sets you up with the state. That's what you filed with with Sunbiz to become incorporated and to become an entity with the state of Florida. Your bylaws, that's again a different document. Now, all of these could be recorded together by the developer. These could all be recorded separately. They could all be amended separately. They could all have different amendment requirements. But your bylaws typically include, notice requirements or how many board members you may have and some other things along those lines. Your declaration typically, and again, it's sort of in the name usually for HOAs, your declaration includes your restrictions, your use restrictions. If you're a 55 and over community, that's typically outlined in your declaration. If you have sale approval rights, that's typically outlined in your declaration. If you have architectural review authority, that's going to be in your declaration. The authority to assess and collect assessments and lien for assessments, that procedure is typically in your declaration. Your declaration, we kind of joke, is your constitution. That's the document we're probably going to be talking about the most today. That's the one that, again, kind of contains these promises, as we say. So you promised to essentially run any architectural modification by the board, and the board is now promising essentially to enforce those restrictions and make sure that nobody in the community paints their house, neon pink. So that's sort of the exchange. You made promises, and then the association is promising you certain things, and that's outlined in this contract, in this declaration that is recorded against the land, against the lot, and runs with the land. Now, and again, like I said, that's your hierarchy. So when we talk about your governing documents, we are talking about that entire group, but ultimately they are different. How do I say? I don't know how to. Hold on.
I think you just need to swap it if you're seeing the full screen.
Yeah.
Yeah, there you go.
That better? Sorry. Oh,
And folks, you will be getting after you fill out the evaluation later, you'll be able to download and save the slides instantly. So you don't have to take crazy notes either if you don't want to. Back to you, Emily.
why is it also transcribing our conversation? I don't know, guys. All right. Well, all right. So that's your governing documents. And when we talk about amending them, like I said, we may be talking about amending all of them. We may be talking about just amending your declaration. That's all going to depend on what it is. So let's dive into some of these topics. First thing you have to be aware of, and I'm always going to tell you the first thing you need to look at is your governing documents. Start by looking at your governing documents and start there. Your amendment process is going to be outlined in the governing documents themselves, most likely. Now, you might have old language. It may say something like, to amend the declaration, it requires a 75% vote of your owners, 75% approval of those voters, something along those lines, or maybe even 2/3. Now, those are high thresholds. It's very hard to get 75% of your owners to do anything, to even, participate. So to get them to approve an amendment, that might be very difficult. If you still have language like that, you might want to look at it and you might want to amend that first. That's really my, big tip from this course. Look at your governing documents, start with your amendment threshold. If your amendment threshold is high, if it is something like 75% or 2/3, think about amending that first. Bring that down to a number or an amount or a threshold that you think is more attainable, but that is still palatable to your owners, because you're going to need to get them on board and get that 75% to approve the new amendment. Bring it down to maybe a majority, but you could bring it down even more. You could bring it down to just a straightforward number. Maybe you're a community of 100 lots. And to you, it makes sense. Well, as long as 40 owners approve something, we think that's enough. So instead of saying 40%, you could just say, we want 40 lots to approve an amendment. That's one way to do it. You could do it where it's, a majority of those who vote as long as quorum is obtained. That's another threshold. But these are all considerations, and it would depend on your community and what makes sense for you. And obviously talk to your attorneys about that. And you want to make sure, again, that initial amendment passes. So it needs to be something that you can get, the support behind. But that's number one. So look at your governing documents and see what your amendment requirements are. And again, they could be different if we're talking about your declaration or your bylaws or your articles, all of that. There's case law that says essentially there's a 5-year statute of limitations on a challenge to recorded amendments. So every now and again, it'll come up where we have documents and someone will say, hey, there was an amendment done in whatever 2019. We don't know if the board actually got the right, vote at the time. We don't know if it was adopted properly. Well, if it was in 2019, we're past the 5-year statute of limitations. We're not going to be able to challenge that amendment at this point. It's essentially deemed valid and we have to deal with it. There are different ways to do the amendments, different considerations when we're talking about presenting an amendment and how your owners, participate, how your owners are going to vote. Are we doing it at a meeting? You're going to look at your governing documents, see if you have a special meeting requirement. Typically, it's a 14-day notice to your owners. It's going to be a membership meeting, an owner meeting, because your owners are voting. Or do you want to do it by written approval? There might be a way, and again, depending on if you're an HOA or a condo and depending on what your governing documents say, you might be able to do it through a mail-out written consent process, which might make it a little bit easier if you could do mail blasts, email blasts, a mailing, and try and kind of get the support that way. You may also realistically need to have some boots on the ground, as they say. You may have to knock on doors. It may have to really be a campaign. You may have to host some town halls to get the support behind it. These are all things you need to be prepared to do if you want to get some amendments in place. If we're doing it through a meeting, odds are you're going to prepare proxies. That makes life a little bit easier. Your owners don't have to physically come to the meeting. They can still vote through that proxy. They can return the proxy to the management team. They can send it with a neighbor or whoever to basically vote for them. Those are all ways to handle it. Then we're going to look at how we're voting. And you really do need your management team involved in this, because you want to make sure that the mail out is done properly. You want to make sure you have enough, manpower at that meeting. If we're talking about verifying proxies, and depending on the size of your community, that process alone could be very time consuming. Proxies could actually be verified in advance of the meeting. That might make life a little bit easier. But all of these things are practical considerations to really kind of talk through with your counsel and talk through with your management team. Certain amendments, depending on, again, your governing documents, might have a different amendment requirement. So you might have sort of a general provision that says to amend this declaration, it requires 75% approval of your owners, or approval from 75% of your owners. But you might have sort of special provisions that say, well, but you can't change this section without a vote of also maybe your mortgagees or 100% of your owners. That might be something involving termination if we're talking about condominiums. That could be you can't have an amendment that's going to impair the developer. Odds are there's a lot of language like that still in your governing documents. Now that might not be something that is a consideration because your developer might be long gone, but it's still something to be aware of. There might be language about, impairing the rights of again, a mortgagee or the lenders, essentially. You have to keep in mind that your governing documents were drafted by the developer, and the developer had a very different goal than you have living in the community. The developer wanted to sell these lots, sell these units, wanted to entice, the lenders to lend in the community because that makes sales easier. So typically they put in language that helps, that goal. That's very different than the goal that you have, again, as an owner and an occupant and a resident of the community. So there might be language that says something like that. If we need the lenders to all agree to this amendment because we're technically, we're impairing their rights in some way. If that's the case, again, talk to your counsel, but there are certain steps you can take. It doesn't really mean that you need to get, Bank of America to sign a proxy for you. It just means you'd have to do a certain title search, find out who those lenders are. You do a mass mailing for the most part. And if they don't respond, essentially it's considered that they've consented. It's a negative notice procedure. And then there you go, and you can kind of move along. You also have to consider when we're doing amendments, have you suspended any voting rights? Does that change the analysis? Does that change our calculations, our numbers? Does that change our quorum requirement? Does that change how many owners, now we need to get to approve something? Leasing and rental restrictions. The amendment, the amendment is going to restrict leasing or any rentals and leasing. Again, if we're talking about condos under 718, or if we're talking even HOAs in 720, this is another consideration. The statutes have changed in recent years where if we're going to amend to restrict leasing, possibly depending on what kind of amendment it is and what community we're in, that amendment may only apply to those who vote in favor or those who take title after. So you may have some owners that maybe they are investors and they don't want to vote to approve a leasing restriction, and they hold out and they don't vote in favor. You need to keep track of that because down the road, if they then want to lease and you tell them, oh, we have this restriction, so you can't lease because of XYZ, they may tell you, oh, that doesn't apply to me though, because I didn't vote in favor and I had already taken title. So I'm not a new owner. I was already an owner. So you are going to have to keep track of those votes. Again, that's a little complicated and there's a whole other analysis that we'll get into that may impact that as well, but I just want you to be aware of it. So there are all these considerations that you need to take into, that you need to consider when we're talking about just preparing amendments and presenting amendments. Now, like we said, why do we even talk about this? Why do we care about amendments? You have documents that have been in place for, 30 years, 40 years, 50 years. Who cares? Why do we have to amend them? Well, you may have documents that have been in place for 50 years, 40 years, however many years. But realistically, you probably have a lot of language in there that is potentially hurting you, potentially exposing you to liability. You may have provisions that, and we put the little dramatic stamp, that are illegal. What we really mean by that is you may have provisions that are discriminatory without realizing that you even have them, because perhaps you don't enforce them, perhaps even just a basic reading of them as a board member, you realize that's something we can't enforce. That doesn't sound right. And you're probably right, but we might as well amend the document and take that out and take that, potential discrimination claim off the table and keep that away from the association. Also, the other big consideration is you might have provisions that are costing you money, or keeping you from collecting more money potentially. And I'm not a gambler. I'm not big on that, but we sort of joke that you're leaving money on the table. That's the expression, right? So we don't want that either. If there's a way for, and again, especially in sort of the way the economy is going now and in today's world, if we can save you some money, if we can help the association collect more money, then great, that benefits everybody, right? So why not do that? Those are the big things. Those are the really sort of the big lenses with which you should really be viewing these changes. So when someone says, well, why are we going to spend all this money to change your documents? They've been fine. We're all fine. We've been, operating for 20 years without any changes. This is why. You may have something in there that could expose you to liability, that could cost you money. And just because it hasn't come up yet doesn't mean it won't. So let's be proactive and trying to avoid these problems before they happen. All right, so we're going to get into sort of some practical applications, some practical scenarios that we we see coming up for our clients all the time. We do this a little bit, when I do this in person, it's a slideshow where I get to say, true or false and ask to see hands, but I can't see you guys, so bear with me. I'm going to assume that you're answering, and then I'm just going to tell you the answer anyway. But let's run some scenarios, okay? A foreclosing lender is required to pay 1% or 12 months of delinquent assessments, true or false? We assume most people go, oh, that's true. Yeah, I know about that. That's safe harbor. I'm familiar. Yep, I know. Got it. Well, false, because we kind of trick you a little bit in the way we phrase this. The 1% or 12 months of delinquent assessments, that does sound familiar. That is supposed to sound familiar because that is safe harbor. You may have heard of that. You might be familiar with that term. Safe harbor essentially means that the first lender, the first mortgage holder, the lender that lends first mortgage gets a certain protection. We call it safe harbor under the statute that says if they foreclose, so if Bank of America has a first mortgage and they foreclose on one of your owners and they take title, so they're superior to the association's interest, they foreclose, the association's interest essentially gets wiped out. Even if you had a lien on the property, it gets wiped out by this foreclosure. What does Bank of America, as the new owner, owe the association? And we still get this question a lot from boards that say, well, Bank of America owes us that whole amount that Mr. Smith owed us, right? Because they're the new owner and owners are joint and severally liable and all that good stuff. Well, safe harbor kicks in. So safe harbor basically says, no, if the lender takes title at their sale of a first mortgage, they get this protection where they only have to pay the lesser of 1% of the mortgage or 12 months of delinquent assessments. Now, don't shoot the messenger. And I should have said that probably in the beginning here. Don't get mad at us because that's the case. Because you're going to say, but now we have to write off, $20,000. Yes, you might have to write off a big chunk of change. That's just the way this works. And that's why we're also going to tell you, you should probably push your collections and your association foreclosure efforts along, because you don't want to be in a spot like that where you do have to write off so much money. But if that's what happens, if Mr. Smith owed you, $25,000 and Bank of America came along, they've proceeded with their foreclosure, they foreclose, they take title, and Bank of America now says, okay, association, how much do we owe you? You're not going to say $25,000. You're going to say whatever this is, the lesser of the 1% of the mortgage or the 12 months of delinquent assessments. And then they owe going forward. So they do still owe you once they've taken title. They're going to pay you your regular, whatever it is, $300 a month for assessments until they turn around and sell it or whatever they're going to do. But that back amount that Mr. Smith owed you, they don't owe that whole amount. Now, it's very important because the reason this slide is in this presentation is your governing documents may say that Bank of America actually doesn't even have to pay the 1% or 12 months. That Bank of America might owe you nothing in back amounts. They might owe you zip, zero, zilch if your governing documents say that. So you have to be really careful because you might have language in your governing documents that is worse, basically, that, basically makes you enabled to collect the maximum amount, because the maximum amount under the statute is what you would be stuck with, the 1% or the 12 months. But if your governing documents have something less and have something, more restrictive, then you're stuck with that. So that's a big one over the last couple of years that associations have really seen that kind of comes up to sort of bite them out of the blue. They don't realize until that foreclosure has gone through and Bank of America says, okay, association, how much do I owe you? And maybe the association says, oh, well, great. So safe harbor, here you go. It's the lesser of the 1% or 12 months. And Bank of America, maybe their counsel actually looks at the governing documents and says, oh, wait a minute. No, we don't owe you anything. Your language and your governing documents say that the first mortgage holder who forecloses owes nothing. Those old amounts get completely wiped out and will only pay you going forward. So lesser of 12 months, 1%, forget about that. That's also gone. That's off the table. So even though it's almost a joke that, yes, the lesser of 1% or 12 months of assessments is not a lot, and you may have to write off money no matter what, it's still better than nothing. So we want to make sure you maximize your recovery, especially in foreclosures, especially following a lender foreclosure. And again, especially in this potential economy and with delinquency sort of on the rise, we want to make sure you can recover as much as you can. That's something that is a very simple amendment, pretty straightforward. We can do that for you, pretty quickly. Your owners typically are behind that. Your owners are going to be aware, wait a minute, oh, this just means the association recovers as much as it possibly can under the statute following a lender foreclosure. And it means potentially less money coming out of, my pocket as an owner. Great, sounds great. I'm all in favor. That one's an easy one. That's one that we tell you, get that on the books. That's something you can get your owners behind. So let's switch gears a little bit. So that's one where, again, you're potentially maximizing recovery. We're sort of adding to the coffers if we can. This is another one that really sort of now harkens back to almost just a change in the statutes and what you guys need to kind of get on board with because the statute has changed. Landscaped grass lawns must cover the bulk of the front yards in our HOA. Now, you may tell me, yes, we do have a policy like that. We don't want people to have, turf. We don't want, whatever it is. Well, your documents may say something like that, but we say, is this true or false? False, because there's language now in the statute, which again, probably came after your documents were written, so you might not even be aware of it, that prohibits the enforcement of governing documents that prevent an owner from installing Florida-friendly landscaping. And that's a very specific term, Florida-friendly landscaping. It has to do with essentially preserving energy and water and making sure we can again, sort of protect the environment a little bit and conserve water. So if some owner wants to put in Florida-friendly landscaping, and again, that term actually does have a meaning under the statute, then you have to approve it, even if you would typically otherwise have a provision that says, no, we want sod in 80% of the yard or something like that. So if they want Florida-friendly landscaping, you may have to allow it under the statute, despite what your governing documents say. So that's an interesting, analysis there, and you're going to need to make sure your governing documents really do sync up to the statute. Otherwise, you could be getting yourself in trouble and end up in a lawsuit with an owner who's very mad that you won't let them plant, succulents in their front yard. Now, I should tell you too, that doesn't mean that turf necessarily is approved. Turf isn't necessarily Florida-friendly landscaping. It's really meant to be more like, cacti, succulents, or sort of rock beds, things that, again, don't require a lot of water. So that was the thinking behind the statute. But that's something that, again, typically most associations don't even know that the statute addresses that at all, and typically have never even heard the term Florida-friendly landscaping. But it is something you should be aware of. All right. Okay. So next one is a little interesting. This one kind of pops up out of nowhere, so to speak. It says, does the board have sole discretion or sole decision-making power when it comes to filing lawsuits? And again, typically most people would go, of course, who else is going to decide? Of course, the board has to, that we elect the board makes these decisions. Of course, it's the board. Well, yes and no. So again, mostly false. there's a provision in the statute that says that the declaration cannot contain a provision prohibiting the association from suing the developer. That obviously, as you can imagine, came from some history in some cases. But sort of the compromise, so to speak, the statute also says that commencing litigation against any party where the amount in controversy is over $100,000 requires the members to vote in favor. So if the board wants to file a lawsuit, again, the declaration on its own can't say, hey, the board can't sue the developer. Can't say that. But again, there was a bit of a compromise. The statute does say if the board, essentially, if the board wants to sue the developer, and they don't say it directly that way, but they say if the board wants to file a lawsuit where the amount in controversy is over $100,000, so probably that would apply if we're talking about suing your developer, that decision requires a membership vote. The members need to vote to authorize the board to do that. So that adds another layer and another sort of hurdle and step into getting to a lawsuit against your developer. That's why I said it was a little bit of a compromise, it seems. But either way, any other kind of lawsuit is going to be up to the board. For the most part, it wouldn't be something you would even think about. But just this specific lawsuit, anything where the amount in controversy is over $100,000, the members are going to have to vote and essentially authorize that, rubber stamp it for the board. And it is a special vote. You need a membership meeting where quorum is obtained, and then it's really just a majority of quorum. So it's not a huge threshold, but just getting to that type of vote and getting your owners to come out to a meeting and getting quorum when we're talking about an HOA, that can be a bit of a challenge. So it is an extra step and an extra hurdle and just something to be aware of. Now, here's a fun topic that we always get into. All new owners go through the screening process in our community, true or false? So we say false. Now, here's the one where, and honestly, we have a whole class basically just devoted to screening and the sale approval process, lease approval process. So this is something where, and this applies in HOAs and condos. Now, if we're talking about, do we screen everybody? Do we screen purchasers? What if they're not a purchaser? What if it's a quitclaim deed? What if the property is being put into the name of a trust? What if the property is being put into the name of an LLC? Who are we screening in that case? Are we reviewing the trustee? Or are we reviewing every occupant who's going to be then coming in and living in the lot or living at the unit? Are we reviewing guests if they are here for too long in our minds? So now they've become an occupant. What about tenants? Is a guest who's there for 90 days, 30 days, 60 days, do they become a tenant? What if they just say they're not paying any money? Now, does that mean we can't screen them? You have to look, and again, this is for condos, HOAs, co-ops, you have to look at your governing documents. This is something that's really not addressed in the statute. Your governing documents are going to control. You need to know what the authority is under your governing documents. And you need to make sure that the authority that you think you have as a board is what you actually do have under your governing documents. Or again, you may sort of stumble into a potentially ugly lawsuit. If you tell an owner that they can't sell their property because you didn't like, their prospective buyer, and lo and behold, you don't even have the authority to review that sale, and now you've just cost that owner a potential sale. If they can't sell to the same price, they have to lower the price. You could potentially be on the hook for, big number of damages here. We could be talking, big amounts. If we're talking about maybe denying a lease, again, maybe the numbers aren't as big and the risk isn't as high and the liability exposure isn't as high, but still, now maybe they can't find another tenant and it takes them 3 months, and now they're going to sue you for 3 months worth of lost rent and those types of damages. So again, if you have the authority, if the language is in your governing documents, you may be able to deny a potential purchaser or a potential tenant. But if you don't, there's potential for serious liability here or exposure to liability. And then you really need to look at, again, what does that mean for your community when we're screening? What's the procedure outlined in your governing documents? Does the application process say that you're going to review and get back to them within 30 days? Does it say 15 days? Does it say 20 days? You need to make sure, obviously, you're following those deadlines, because again, you might have a savvy owner, landlord who says, well, you had the application now for 25 days. You were supposed to reply within 20. If you didn't deny me within 20, it's deemed approved. That's what the governing documents say. So I'm moving my tenant in no matter what, you guys, even if you didn't answer me. And that could be the case. And you could be sort of stuck. Well, we didn't want to approve them, but we were waiting to have our board meeting or whatever it is. These are all considerations and all things you have to think about when you're looking at your governing documents, because that's where that procedure is. That's where that process is. That's where those deadlines are. The biggest thing really is when we're talking about good cause criteria. Essentially, do we have a reason to disapprove this purchaser or this tenant? You might have some generic language in there that basically you could apply to say, well, we looked at this person's finances and clearly their finances seem to indicate they can't afford to live here. We know what the regular assessments are, and we know what this person's income is, and it just doesn't sort of sync up. We don't think they can afford to live here. Fine. That may be something you can have as sort of your general, generic old language that you might have in your deck right now. But do you want more specific language? Probably. Do you want language that says, hey, we're going to be looking at past bankruptcies. We're going to be looking at criminal history too. And again, that's a sensitive topic, and we can talk about that a little bit more down the road. But that's something now you want to phrase that the right way. We want to say, hey, if there's any fines or charges against this unit, we're not approving a tenant until those are paid. You can outline all of this criteria that can be considered for every potential sale, every potential lease, every quitclaim deed, even for an inheritance. If you're a 55 and over community, you may have a lot of properties that transfer through a trust or transfer just through inheritance that, mom was here for, a million years. She's 80 years old. She passes away, and all of a sudden her 55-year-old son moves in. Well, there's no reason that he can't be here. He's now the new owner and he's 55. So he fits under our 55 and over criteria. But we really wanted to screen him because we've done a little, Googling on him, and it looks like from what we're finding out on the internet that he's not such a great guy. He has some criminal stuff. He has some, he's basically, it sounds like he's a bum. He doesn't have a job. He doesn't have whatever. Well, your documents might not say that you get to screen him if he just inherited the property. Your documents might not address it at all because you screened mom. Mom was a perfectly fine applicant, but now he got the property through an inheritance. Or maybe it's not even that he got it through the inheritance. Maybe in the scenario, mom's still alive, but son moves in. Do you have the authority to review him as an occupant or an additional occupant? Again, if you're 55 and over, it would be nice to be able to say, well, he's not 55, so he can't live here alone. But okay, what if in this scenario, mom's still around, she's 80 and he's 40? And we do have owners that will say, well, we Googled it and he's a bum and we don't want him here. Well, you have no basis to deny him if you don't have the authority to review additional occupants. And there's no age restriction really if mom is still there and she's 80. We've sort of checked that box. So all of these considerations, if you want to be able to check and screen all of these people, additional occupants, people who inherit, all of that, you need the authority in your governing documents. And odds are if you have old documents, that language is either not as clear as you want it to be or doesn't apply to sort of everybody. Probably only says sales and leases. Again, does that include a quitclaim deed? Maybe, maybe not. Does that include an inheritance? Maybe, maybe not. Really is going to depend on the language in your governing documents. All right, here's another hot topic that you'll hear probably in every course you take in the next couple months. Once the law changes, the change is automatically applicable to your community, true or false? Well, this is another one where it depends. So sometimes the law applies if the new law is procedural or remedial in nature. The problem is there's a whole sort of constitutional argument here, and it gets into a very complicated legal discussion. There's certain language that you may hear referred to as Kaufman language. And that means if your governing documents have certain language, maybe they say this declaration is subject to Chapter 720. We're assuming we're in HOA world. Chapter 720 as it's amended from time to time. Then that's the Kaufman language. That means, okay, our declaration is going to change with 720 as 720 gets amended. So we don't have to amend every time 720 is amended because we're following the statute as it changes, and we're subject to the statute as it changes. But if you don't have that language, then there's always a question of, well, our declaration was recorded in the year 2000. So does our declaration follow the statutes as they were in place in the year 2000? Or do they follow as the statute has changed? And this is where we said, again, it depends. If the change to the statute is something that is considered procedural, then it's still going to apply. You're still going to follow it. But the constitutional part, the more complicated discussion is the law cannot change a fundamental contract right unless there's a compelling public policy need. So essentially, if your governing documents have certain restrictions that are considered, a contract right, because if you remember, your declaration is a contract, there's an argument that the statute cannot then supersede that contract right. So if it's something procedural, like in the easiest example, even though we're talking mostly about HOAs today, the easiest example is in the world of 718 with condominiums. The statute changed how the elections are done, changed how the notices are done, and that's essentially considered procedural. They have to have 2 notices, 60 days, 14 days, and that's how their election is. Every condominium election is conducted the exact same way, essentially, because they put it in the statute. So regardless of what your declaration may have said back in the day, if you're in a condominium, you follow the same procedure outlined in 718. So that's where this argument always comes up. So lately, there have been some changes, especially in the world of 720 and in HOA world, that have impacted a lot of HOAs, where now there's language about, you can't enforce a prohibition against trucks, certain trucks, work trucks. And people are able to park their work trucks where they want to park them if they're able to park them legally in the community. So if your declaration, all of a sudden you can't put in a restriction that says, hey, no work trucks parked in the driveway. Well, there's an argument now to be made. Well, our governing documents don't have Kaufman language. Our governing documents have already had a restriction that said you can't park your work trucks in our driveways. So the argument is the statute changing and saying you can't enforce that restriction impairs our substantive right to have that truck restriction because we already had it. So we don't have to follow the change to the statute. We're going to continue to enforce the truck restriction that we already had because it's our substantive right, essentially, and the statute can't impair our substantive right and our contract rights. Again, it's sort of a complicated legal analysis, but you need to talk to your counsel about it. It has to do with changes now to trucks, changes that they put in 720 about what you could potentially put in your backyard. You can't enforce a prohibition against things that are placed in the backyard unless they're seen by essentially a neighboring parcel or the front parcel or a neighboring, common area, golf course, something like that. But the same discussion comes up. Well, wait a minute. We don't have Kaufman language. We don't have to follow the statute as it changes. Our governing documents already said you can't put up a shed in the backyard. So we still want to be able to enforce our no sheds in the backyard provision. Well, now because there's this change in the statute that you can't enforce any prohibition against putting things in the backyard, and it has to do with almost anything, storing an RV in the backyard, a boat, whatever it may be. These are all conversations you need to have with your counsel to see if that change to the statute applies to you, if you still can enforce that prohibition, if you had that restriction already. If you didn't have that restriction already, then you're stuck. You're not going to be able to add it in now. But these are all things to consider. And if you have that language already in your governing documents, maybe you don't want to add the Kaufman language. Before, we were recommending that associations would add it because it was better typically to change your governing documents along with the statute without having to do a formal amendment every single time and have a membership vote and to do all of that. But now, because the legislature, and again, I won't blame all you guys in Tallahassee, but we'll say Tallahassee, made these changes in recent years that have become more unit owner friendly and less association friendly, we'll say. it might not benefit you to now have Kaufman language. It might be better to have the restrictions in your declaration that you had before and not subject your entire declaration essentially to changes to the statute. There are still ways that maybe you want certain sections to change with the statute, like recovery after assessments. That's again something that you need to discuss with your counsel and really kind of get into the nitty-gritty with. But all considerations that we want you to kind of start thinking about when you're talking about amending your documents. So this is another one that deals with changes to the statute and sort of energy efficiency. Residents are prohibited from having clotheslines in your HOA, true or false? Usually owners, again, when we're in person, will say, oh yeah, we don't allow clotheslines. Our documents say you can't have a clothesline. Now, technically, this is a statute that you may not have heard of because it's not 720, it's not 718. It's 163, chapter 163 of Florida statutes. Prohibits HOAs from enforcing documents that prohibit energy devices based on renewable resources. So this includes clotheslines. So if somebody wants to have a clothesline because essentially they want to conserve energy, they don't want to use a dryer every time, they want to hang their clothes out to dry. If your declaration says no clotheslines, that's a problem because the statute is going to sort of trump your declaration. You may be able to kind of work around it. You may be able to say, well, no clotheslines in the front yard. But again, talk to your attorneys about that. But it's important to know it's not just clotheslines. That typically isn't something that even really comes up as often nowadays. It's solar panels. That's the big one that will come up. Hey, somebody wants to put solar panels on their roof and we told them they can't because they're ugly and we don't want to look at them. And we have ARC approval and nobody else has solar panels. So we're going to tell them no, but now they're pushing back and saying, we can't tell them no. What's the story, attorney? Please help us. So solar panels, again, the same statute is what's going to come into play. You have to allow solar panels, but there's a but. You can sort of control to a certain extent how they're installed or where they're installed, if possible, potentially. But there's, again, another big but here. If these solar panels cannot operate, you have to allow them to be installed in a certain way. So you can't just have a blanket rule that says you can't put solar panels, on the front facing portion of the roof. Depending on the orientation of the lot and the house and all of that, those solar panels may only be able to function on the front part of the roof. And if that's the case, you're going to have to allow it even if you don't want to, and even if you say, but it's ugly. Essentially, the statute's going to come in and say, but we value energy efficiency, so we want people to be able to have solar panels. And even though, board, we're sorry that you're saying, it's ugly because it's on the front of the house, you may have to allow it. But that's a maybe. It depends, again, if they can function in sort of with a different orientation. But that's a big consideration because if you don't allow that and you just say, well, we have a rule, no solar panels, or we have a rule, no solar panels on the front of the house, you may walk yourself into a lawsuit because an owner may say, you can't tell me no, and I'm going to sue you now because you've cost me all this money or whatever it is. All right. All right. Delinquent assessments accrue interest at the rate of 18% and a $25 late fee applies, true or false? Again, those probably sound familiar. Those are familiar sounding numbers because that is essentially what the statute says. However, the statutes, and this is the three that we talk about, the condo 718, co-op 719, HOA 720, the authority to charge late fees and to charge interest has to be in your governing documents to start with. So statute's going to say, yes, you can charge interest. The highest rate is 18%. You can charge a late fee, $25, whatever it may be, but that authority has to be in your governing documents first. So it's not just an automatic, hey, we charge $25. Make sure your governing documents actually say that. Otherwise, again, you may be getting yourself in trouble if you're charging these things that you're not technically allowed to charge. And you can walk into, a fair debt claim, a lawsuit that you're charging amounts you're not supposed to be charging. And again, those are potentially big claims and serious lawsuits that you're going to have to defend yourself against. And more importantly, you want to be able to collect as much as you could possibly collect when we have a delinquent owner. So again, you're leaving money on the table if your governing documents don't authorize you to charge the maximum amount under the law. So make sure they do. If your attorneys tell you, hey, you guys can't charge late fees, then again, that's a pretty simple amendment. We can put that into your governing documents. Your owners will probably vote in favor of it. That's usually a pretty easy one. Now this one's a little more tricky. A pipe in a wall serving one unit is a maintenance responsibility of that unit owner. So this again, sort of probably typically has to do more with condos, but not always. We have a lot of HOAs that are also townhomes or villa homes or whatever it is. So we get that question. Well, who takes care of what, essentially? And really the issue is, and we use the hypothetical of a wall or the pipe in the wall serving one unit, but the bottom line is your maintenance requirements, again, not outlined in the statute. 718, 720 pretty much don't say anything about maintenance. The maintenance requirements are going to be whatever is outlined in your governing documents. Now, that could be different than maybe an insurable claim. If we're talking damage from a hurricane, sort of put a pin in that. That's a different issue potentially. But if we're just talking regular maintenance, hey, this pipe is old and it cracked and it leaked. Who's responsible to fix it? And then who's responsible to fix all the damage from, whatever it may be. Was it a slow leak? All of these questions, and this is going to come into play. But bottom line, your governing documents are going to control. So your governing documents need to be clear. Did they say that, the owners take care of the unit and then the boundaries of the unit are basically, as managers like to just say, from the paint in? That is an easy sort of cheat, but think of it that way. Is that that the owner's responsible for, and then the association's responsible for sort of everything out in in those walls, in those pipes, the pipes that are going through the common elements? Or again, do your documents say something different? Do they identify, well, if a pipe's actually only serving one unit, which sometimes that is what it will say, then that pipe really just belongs to that one unit owner, and that one unit owner is responsible for that maintenance and that repair. That could be the case too, but that's going to be something that has to be in your governing documents. And that, again, like I said, could be in the world of 718 or 720 if we're talking about townhomes. If you want to make certain maintenance items an owner's responsibility, or indicate in your governing documents that actually the association will take it on, but we're going to charge the cost of that repair back to that unit owner. That's another way to handle it. That's something too that you can't just do willy-nilly. It has to be outlined in your governing documents. You have to have the authority to do it. The board may say, well, it's a pipe, so we're going to take care of it. But if your documents say, hey, that's a pipe that the owner's supposed to repair, it might be something where you say, well, we don't want the owner's plumber, getting in the walls and messing with our stuff. We'd rather do it. But maybe there's authority to say, well, we'll take it on as the repair. We'll have our guy do it, but then we're going to charge that amount back to that owner because that's the owner's responsibility. At least the cost is. But that would be something that would have to be outlined in your governing documents. All right. So I know this class is a little interesting because we kind of cover a whole bunch of different topics all at once, and a whole bunch of different points that we want you to think about and consider. Now, another thing to keep in mind too that I didn't mention today, if you are in the world of an HOA, if you're governed by 720, another thing for you to be aware of is if your governing documents are older than 30 years, you need to make sure they've been preserved. And I know that's sort of a funny way to say this, but the statute essentially states that basically after 30 years, certain covenants will expire. And your declaration is a declaration of covenants. And this is only for HOAs, it's not for condos. Because of the way that condos are built, it's just different. So declaration of covenants, your covenants can expire after 30 years. You can preserve them within that 30-year window, and that's a board vote, board decision. You record something in the public records and you're good for another 30 years. But if we're outside of that 30 years, now you have to do a different process. It's called a revitalization. And you need to get your attorneys involved because before you even amend any documents, you're going to have to get your documents sort of current and make sure that they haven't expired essentially. It's really not your documents, it's your covenants that would expire. But again, talk to your counsel. That 30-year mark is very important if you're in an HOA. So I just want you to be aware of that. Check into that and look at that. We have had clients come to us who say, hey, we need amendments. Our documents are old. We want to make sure we update everything. No one's touched them in 40 years. And then I look at them and say, oh, yeah, well, you're right. No one's touched them in 40 years. Actually, your covenants have expired. And we got to take care of that first before we get to any amendments. And that's a membership vote. So that is something that is a bit of a challenge to get done. But be aware of that. That's called the Marketable Record Title Act, or MARTA. You'll hear people say those initials. Look into that, but that's only for HOAs. That's only for 720. So again, 30 years, you want to make sure you've preserved your governing documents or you've revitalized them if you're after the 30 years. Very, very important, because before we do any amendments, we got to make sure that we're working on, a strong foundation. So we'll just hit some key points again, reminders for what you might want to take away from today. Safe harbor, mortgagee liability. Again, you might be leaving money on the table because your documents might limit your recovery. If you have old language in your documents, it might be worse than what you would get under the statute. And what you get under the statute isn't great, to be honest. So you'd want to maximize your recovery. That's one thing to look at. Architectural guidelines and requirements that you have need to account for these renewable resources. Like we said, for these new changes that encourage energy efficiency, those are things to consider. You might need to update those. And if you don't, you might be, on the wrong side of some liability. Powers that are granted by the governing documents might also be limited by statute. You might be losing money when we talk about interest and late fees. You want to make sure you can recover as much as you can recover. So again, we want to make sure you can maximize, your recovery, and that's authority that might have to be in your governing documents that you might have to amend. Right of first refusal, that's different than the rights of approval. That's when we were talking about sale authority and the ability to review sales, the ability to review leases, and all of those things also then kind of get you into potential discrimination claims. Those are other things that expose you to liability. So we want to make sure you have that authority and you're doing it properly so you're not on the wrong end of a discrimination claim. You want to look at your governing documents with respect to some new laws, either incorporate the new laws into your governing documents, or maybe there's a discussion where some of them might not apply to your governing documents, but you won't know that without taking a look. And old language in the documents might expose the association to discrimination claims. So like I said, a lot of old language, you'll see language in your governing documents sometimes. A lot of our 55 and over communities will still have an old, section or an old sentence thrown in there that says, no children under 16 can live here. Sometimes that random sentence is in there for a community that's not a 55 and over. And that's not what the law says, by the way. So if you have language like that, again, a family who wants to come live in your community might say, hey, you have a provision in here that discriminates against us with our familial status. And you might be subject to a discrimination claim and a discrimination lawsuit just because you have old language that you didn't even realize was in there. And again, you probably haven't enforced it in years, but maybe you just didn't even realize. But if your declaration says something like that, says, hey, no children under 16, that's something you need to fix and you need to remove, immediately. Otherwise, those discrimination claims can be lengthy and expensive for you. And even when you win, you don't get any money back. That's money that's spent to defend the claim, and that's it. So worst case, you end up with a penalty or some sort of, financial penalty. Best case scenario, you've just spent a whole lot of money on attorney's fees and you won. So either way, you don't want to deal with the discrimination claim if we can avoid it. All right, so those are the highlights, and that we can take out. We just put this in here sort of to remind you guys that the big question we always get at the end is, hey, how do we get any assessments passed because our owners just aren't involved? And we started with this conversation, and we'll bring it sort of full circle. First thing is look at your voting requirements, see what your amendment requirements are. First step, before I draft a million amendments for you and spend all the time to do it, let's get your amendment threshold down to a more attainable figure, again, maybe a majority. And the easiest way to do that is potentially get electronic voting in your community. If you don't have it, then really you're making voting more difficult for your owners. If you can do the electronic voting, which again now seems to be a little more cost effective than it was when it first came out, you can get your owners to really participate, hopefully, and those owners who are maybe snowbirds or who are, out of town most of the time, or, they're Miami based, but they're actually in South America half the year, whatever it is, then they can still vote, they can still participate. It's easy for them to send an email or to vote through this email procedure. That might be another way to get encourage some participation. So that's just something we throw in here at the end to keep you up to date with. All right, so that's the whole presentation, guys.
Excellent.
Let's.
Thank you, Emily. So, Jeff, did you want to say a few things before we got into Q&A?
Yeah, just going to mention, folks, thank you, Michael and Emily. Great job as always. Just want to mention everybody, if you haven't already pressed the chat button so it appears on your screen, please do that now because you will not see items placed in there earlier. So do that now. We're going to place the evaluation link in there for a third time. We'll do it again in about 10 seconds. So press the chat button. You'll click on the link. It'll open up in your browser. You'll fill it out. You'll submit it. And then after you submit it, you're taken to a confirmation of submission screen. And then that screen will have a link to download and save the slides instantly, as well as everybody's contact information. But I'll go over that again at the end. When Emily and Michael are done with the questions, I will come back after they leave to help anybody out still struggling with the evaluation. Back to you both.
Awesome. So let's go over some Q&A. So the first one I see here is, what is necessary in changing just the rules and regulations? Do we need a meeting or votes for that?
Good question, because we didn't really touch on rules too much today. So thank you for bringing that up. Rules are typically a little different because if you remember in the beginning, we said they're sort of at the bottom of the hierarchy here. So typically, if we're talking rules, it's probably a board decision, it's probably a board vote. You probably don't need the owners to vote. Now, if it's a board vote where we're going to be impacting somehow unit use or parcel use, it's going to be a special board meeting. So it's a 14-day notice instead of the 48-hour notice. But again, look at your governing documents, because every now and again, some governing documents will say that rules need to be approved by the owners too. It's rare, but it does happen. So we don't want you to put new rules into place and then sort of realize later on, oh, wait a minute, we didn't have the members confirm that they wanted these. And now you have an owner pushing back on one of those rules. Another thing to consider is your rules are a little different because, again, they're sort of at the bottom of that hierarchy. They have to be enforceable. The board has to have the authority to adopt them. That's usually somewhere in your declaration. It'll be thrown in there that the board can adopt some rules and regulations. And they have to not conflict with any other restriction that's in the governing documents. And they have to be reasonable. Reasonable, again, is a little subjective, so that's always a little tricky. Most of the rules our clients come up with are reasonable, fingers crossed. But the bigger issue is that they can't conflict with what's already in your governing documents. So that means, and this is where it gets a little, we're talking sort of double negatives here. If there's no restriction in the declaration already, and you're creating a new restriction, then potentially that's a conflict because your declaration was unrestricted, and now you're adding a restriction. So again, it can be a little more complicated than it seems, but talk to your counsel before you sort of create all new rules, because they may tell you, hey, this really can't be done as a rule. That should be an amendment to your declaration, and that should be something that your owners vote to include. So.
Gotcha.
Yeah.
So then the next question here is, if the association were to foreclose on a property before the first lien holder, can they collect the full amount due on delinquent assessments?
Good question too. So, and now again, I think we are probably going to see more of a rise in foreclosures nowadays. The association, when the association forecloses, so there's a bunch of steps in collections that you guys probably already know about. Management sends out a notice of late assessment or a NOLA, gives them 30 days to pay. Then once you turn it over to foreclosure to your attorneys, we still have to send 2 more statutory notices before we get to foreclosure. So there's 2 more notices that go out, hey, we're going to record a claim lien against your property, 45 days to pay before we do it. Then, hey, it's been 45 days. We recorded this claim lien against your property. You have one last chance to pay before we go to foreclosure. If that owner doesn't pay, now we're going to foreclosure. We file a foreclosure, we're foreclosing that claim of lien. If we get so far that we get a final judgment and the judge enters a final judgment and sets a sale date, that sale is going to be in the judgment amount. So it's the association's judgment amount, whatever it is, $20,000 that this owner hasn't paid. That's what the property is going to be sold for. And I say that loosely because, again, if someone bids over that amount, if you have a random investor who decides to come in and purchase the property and they pay over that amount, the association gets their judgment amount. The association is essentially made whole. We have a new owner of the property and association got its money. That's best case scenario. Now, there may still be a lender out there that forecloses later, but for now, the association got its money and you have a new owner. Great. What may also happen, the association may not get a higher bidder. Someone might not bid the $20,000, and ultimately the association ends up taking title. So that's the default. If no one bids higher than that judgment amount, the association ends up taking title. And that's good and bad. Potentially now you've sort of stopped the bleeding. Now you can, the association took title. So the association hypothetically could put a renter in. And now you could start making money off of that unit and sort of paying yourselves back almost while you're waiting potentially for the bank to do their foreclosure or to complete their action if they even have one pending. But there's one way, you get paid, again, if a purchaser purchases or you take title, you're not going to get paid if you take title because you now have the unit as the association. So you didn't get your judgment amount, but you have the unit and you could rent the unit. So again, good and bad. But yes, if you proceed to foreclosure, there is a way that you get your money back, but not guaranteed.
Great. Thank you, Emily. This is a specific example. So it says, the question is that the HOA is 35 years old. It has a clubhouse and restaurant, but has never had a restaurant minimum charge for the owners. Our governing documents are silent on this. In order to initiate a minimum, what is necessary? Is it a board decision, owner vote?
Quite specific.
Yeah.
I for sure would have to look at your governing documents for that one, because that may be, again, you guys might be set up in a certain way. I don't know if the restaurant is really part of the association. If it, odds are you probably need some sort of amendment, but again, I'd have to look at your governing documents for that one.
I can attest to Emily's answer there, as I managed a property for 18 years with a situation like that. Even though it was a condominium, it all depends on, like Emily said, what your governing documents say, what the rental lease agreement says.
I'm gonna say there might be other agreements too.
Correct.
Yeah.
Correct. Anyway, back to you guys.
So, thank you for that. So another question is, if the governing docs contain provisions for 700 credit score for each applicant, specifically for the buyer, can the screening application be denied even if the potential buyer was approved for a mortgage?
Essentially, you guys as the association, you follow what's in your governing documents. Just because the owner gets approved for a mortgage, that has nothing to do with what your requirements are. So that's a separate analysis. I mean, it might be something you consider just, okay, great, they got approved for a mortgage. But if your requirement is a 700 credit score and it's in your governing documents, that might be something you can still enforce, regardless of whether or not they're approved for a mortgage.
Right. And I have time for one more here. So if an HOA has Kaufman language, does being able to view something in the backyard from a neighborhood 2-story single family home count?
So this is the one we alluded to before. A couple years ago, they put it in the statute that now you can't enforce a prohibition or a covenant that basically prohibits people from putting things in their backyard. We joke because the story is probably that there was some member of legislature who, the rumor was, I should say, who wanted to be able to keep his boat in his backyard, bottom line. And the association had language that said you can't keep boats in the backyard. And so lo and behold, now we have this new provision, the statute, that says you can't enforce something that says you can't do something basically in your backyard unless it's visible from the front of the basically the street or a neighboring parcel or a golf course in the back or whatever else. So the statute's been tweaked a couple times, but bottom line, if you have Kaufman language, so if you have the language that says you're subject to the statute as it's amended, then your hands are a bit tied because now the statute says you can't enforce that unless it's visible from the neighboring parcel. So again, depending on how big the lot is, or depending on if there's a big hedge or whatever it is, if you can't see it from the neighboring parcel or from the golf course in the back or from the front, from the street, odds are you're probably not enforcing it now. Now, how you even would have known about it, I don't know. Again, it gets very complicated when sort of you break down that change to the statute, because I have a client that's, their townhomes. In a townhome, in theory, the next door neighbor can see everything happening in the neighbor's backyard. So all of those restrictions, I'd say, are still free game because the next door neighbors can see everybody's yard. But in that case, if you have Kaufman language and you can't see it, ultimately, you probably can't enforce a prohibition against whatever it is, the shed, the boat, the RV. Yeah. But it is a complicated analysis. Talk to your attorneys.
Thank you, Emily. So before we close out, I want to give you the final word. Any closing thoughts you want to leave with the attendees of this meeting today?
Thank you, Michael. The big takeaway is sort of what we started with. It sounds silly to keep saying it, but look at your governing documents. If you're thinking about amending, first thing I would look at is look at your amendment provision. Let's amend that first, get that down to a number that's going to be actually attainable, and then go from there. And then you guys have a good idea of what what things need to change in the community, and then communicate with your counsel and make sure they can draft the documents to suit your community. We don't live there. We don't know what is the most important thing to you, but you do. So open up the dialogue and tell us what's most important to you.
Emily, thank you so much for your time and expertise today. And to everyone who joined, thank you for trusting us with an hour of your day.